Good morning. May it please the court. My name is Amy Gilbrow. I represent the plaintiff appellant in this case, Kristen Collard. This is a Social Security disability matter that was filed in 2016. The decision at issue is the third ALJ decision in this case. There were two prior district court proceedings before the most recent district court affirmed, and we appealed to the court. Ms. Collard's alleged onset date is June 29th of 2016. She has a date last insured of December 31st, 2021. That means that in order to establish eligibility for benefits, she needs to show that her disability started before that date. And anything that happened after that date is not helpful in establishing that she's disabled for the purpose of the regulations. This is a case that's primarily about a condition called fibromyalgia syndrome. Fibromyalgia is characterized by widespread pain. It's established by the presence of tender points in an individual's body. It's important to note that the symptoms wax and wane. That is supported by the court's decision in Revels, which is cited in our briefs. Also, the Social Security ruling 12-2P, which talks about how the commissioner considers fibromyalgia. And it's also addressed in the Appeals Council's prior remand order in this case, which is at AR page 660 to 662.
It seemed to me that the focus here has to be on these findings with respect to her reporting of her pain and then the ALJ's determinations. So I have a couple questions about that. What impact would there be on your case if we were to affirm the finding with respect to the doctors, but reverse the findings regarding the subjective testimony findings?
Judge McKeown, I think that the credibility finding and her testimony finding is actually the strongest argument in this case, and that if you affirmed the ALJ's findings as to Dr. Brown and Dr. Brecht, you could still reverse the case based on the improper credibility assessment, and that's what I wanted to focus on.
And you're not, of course, asking for an award of benefits at this stage.
No, I am not. I am asking the court to remand the case for further consideration of Dr. Brown's opinion. Of her testimony, also Dr. Brown's opinion and Dr. Brecht's opinion, but the court could remand just for further consideration of her testimony and affirm on the doctor's opinion.
The lay witness testimony is to the same effect, isn't it?
Yes, and I think the lay witness testimony is also a strong consideration in this case, Judge. There were several lay witnesses. The Social Security ruling actually says that the commissioner should consider lay witness testimony in a case like fibromyalgia where there's not as many objective findings. So the commissioner is directed to look at opinions or statements from people who know the claimant or have worked with them, like her coworker who provided a statement in this case. I think the lay witness is a particularly weak point for the government in this case. The judge mischaracterized that testimony as we described in our brief. She found that the lay witness testimony was not specific enough, that it simply showed that Ms. Collard's condition declined without providing any specific information. But the statements from Ms. Collard's friends and family is definitely inconsistent with the judge's finding, which is that Ms. Collard could perform regular, full-time, sustained light work. The vocational expert testimony in this case, especially the most recent hearing, shows that if an individual is absent more than 6 to 8 days a year, they would not be sustained as an employee.
Would you focus on the finding with respect to her work history, because she was working in a reasonably high-stress environment, but of course she is claiming that it's wrong for the ALJ to basically say, well, because she was working there, therefore it is at odds with her claim of disability.
The district court really wrestled with this. Ms. Collard had testified that leading up to the time that she took a medical layoff from work, she was struggling to work at that position. She had exhausted all of her leave under the Family Medical Leave Act, which supports a determination that she'd be absent more than 6 to 8 days a month. She was struggling to complete her work. Her coworker reported that she was absent much of the time. she was performing a heavier job, or what the commissioner would call, or what's defined as a medium job, as a certified nurse aide. That is a more strenuous job than the judge returned her to. He found she could do light work. But Ms. Collard's testimony and the statements of her friends and family show that she's not able to sustain work or sitting, standing, and walking for any sustained periods of time, not just limited in her ability to perform more strenuous work. And she had a good work history, Judge. She worked consistently from 1991 through when she stopped working in 2016. She struggled to continue working. She started having pain issues in 2009. She testified that she enjoyed working, and she would not have stopped working but for the pain that she was experiencing.
So there's sort of I quit, you're fired situation here, and that is ALJ says, nope, you're laid off, and she said, no, it was a voluntary layoff in light of the circumstances of the company and her health. What do we make of that?
If she stopped working because of her health, I mean, there's two separate things. I mean, I don't think the judge's determination that she was simply laid off is supported on this record. She testified,
as it would be if for poor performance in the same way. Is that what you mean when you say
exactly?
It's not that it's so. When you said unsupported, if you could clarify.
What I mean is that I think the judge. My assumption is that my reading is that the judge is saying she was laid off. You know, they didn't have any work for her. They decided to lay her off for reasons unrelated to her medical difficulties. Whereas Ms. Collard testified she stopped working purely because of the problems that she was having with pain.
So could I just I interrupted Judge McEwen's question. I don't want you to lose sight of that thread. I think this is an important sort of subpoint. So maybe if you could clarify and then circle back to Judge McEwen's question. I think it's right in the record that she took this. Well, here, just correct me if I'm wrong. My understanding is that the employer, that she said she'd been having trouble for some time, which would be consistent with the nature of her ailments. And I think the employer lost a contract and then was going to cut back and give her an opportunity to take an early out. I'll use that word so we don't characterize it one way or another. And her testimony is that she did that, but she did that because she was having trouble keeping up, essentially, having additional difficulty on the job.
That's my understanding. I don't think it's ever simple.
Right. Okay.
I think that our main point is that the reason she stopped working, or she decided to stop working, was because she was having difficulty related to her symptoms.
Okay. So I'll put a little bit more time on your clock. I just took a minute of your time, but could you circle back? You're answering Judge McEwen's question.
That's really part and parcel of the answer, is this conflict between how the ALJ characterized it and then your comment. So we'll ask the government about that.
Okay.
Thank you.
Any other questions?
I'm good.
Any other questions at this point? Not at this point.
Thank you.
Thank you.
Thank you. When you come back, counsel, we'll put 2.5 minutes on the clock so you can plan on that, please.
You've been here before.
Oh, I have. Good morning.
Good morning.
Catherine Watson for the commissioner. As has been noted, Collard worked through January of 2016 at a job that, by her own testimony, would have been heavy, although it is generally medium work. She, according to her documents and statements, she was lifting patients that were at or over 100 pounds, and she was frequently lifting 50 pounds. Now, the ALJ agreed that she could no longer perform this work. The ALJ instead found that by the time she alleged disability, she could perform a range of light jobs. And I note that the company did not lay her off because of her impairments. They laid her off because she lost a contract with Group Health. And as early as January of 2016, which is 5 months before the alleged onset date, so at the time she decided to take the severance package, she stated that she was going to take the severance package and go on disability, and that's on CAR 290.
What is there something wrong with that? Given that she was her testimony seems consistent. She was struggling to do the job,
Correct.
and then there was this circumstance that really wasn't the employer's fault or hers fault. It just there was going to be less work to do. And so
Correct.
they offered her this. Isn't that consistent with the finding that she was struggling to keep up?
I think the ALJ agreed with that finding. The ALJ agreed that she could no longer perform this work, but the ALJ found it significant that up until January of 2016, she was at a job where she had shifts 12 hours a day. She was on her feet. She was lifting up or over 100 pounds. And she also did not decide to go part-time. She did not ask for any formal accommodations at this job. And she did leave in part, according to her testimony, she left in part because of her impairments, but the company did not fire her because of her impairments. And in fact, in 2014 and 2015, they gave her raises at this job because she was, quote, good at this job. Now, I agree we'd have an issue if the ALJ found she could just go back to this work. I would certainly understand the issue there, but the ALJ didn't. The ALJ agreed that there was some decline in her condition over this period that she was working, and he ultimately determined that she could no longer work at this job, but that she could perform instead a very reduced range of light work where she wasn't going to be lifting more than 20 pounds, so vastly less than what she was doing.
The difficulty before we move on to the possible alternative jobs is that in your brief, and then also the ALJ kind of basically said, well, she worked consistently between 2005 and 2016, and that really conflicts with her claims about being able to perform. But it seems to me from reading the record that doesn't take into account that her pain worsens over this time. She asks for these days off. She takes family medical leave. And so your position would seem to be, what it would lead to is that people who try to keep working, even though they are under pain and taking medical leave, you just get penalized because you try. And so that doesn't seem right to me.
I think this salient point that the ALJ was making, and I just note this was a 25-page single-space decision where the ALJ really grappled with the evidence. And the ALJ did acknowledge her testimony. The ALJ acknowledged a decline. The ALJ agreed she could not return to this job. So the overall crux of the ALJ's decision certainly acknowledges the points that Judge McEwen, you're making here. However, the ALJ also found it notable that the amount of strenuous activity in this job was very, very high. And so it was reasonable, or it's certainly our position that it was reasonable for the ALJ to conclude that if she could work this very heavy job without going part-time, without asking for formal accommodations, and even with receiving raises, because she was good at this job and because her employers found her good at this job, that yes, there was sufficient decline that she could no longer return to this work. But that's not sufficient under the Act for getting disability benefits. The only question is, are there any other jobs she could perform? And so the ALJ reduced the amount of work, reduced the type of work that she could perform considerably and found that she could perform a range of light. And I'd also note the ALJ did not just rely on work history as a basis for this finding. For example, the ALJ also discussed her activities and identified clear inconsistencies between her testimony on the one hand, as well as the doctor's statements on the one hand, and then what the medical record showed on the other. And I'll just give a few examples. She alleged she could not lift over 10 pounds. She alleged that she was never able to lift her grandchildren. She alleged that she could not lift her dog. And her doctors similarly said she could not lift more than 10 pounds. The treatment records show the exact opposite. The treatment records show on car 883, she had to lift her father, who presumably would be more than 20 pounds, when she was caring for him in 2020. She told Dr. Gassel that she occasionally carried her grandchildren, who were about 20 pounds each. And physical therapy notes show that after she injured her surgery, so presumably was even more limited, she very quickly met her goal of lifting 10 pounds, quote, without difficulty, unquote, and she also was able to lift her dog. So the treatment records show the opposite of what she's alleging. She alleged that she had 15 to 20 pain flares a month, that's on car 605, that she was effectively bedridden, that she was unable to walk, that's on car 1457, that even on good days, she spent half the day lying down. But her statements to providers were quite different, and to medical sources. She told her provider repeatedly that the current dose of pain medicates were helping her to take care of her activities of living, that she was more active caring for her grandkids, that she was able to drive her parents to do the errands they needed, and that she drove when she needed to drive. She said that she did grocery shopping with her mother, that she was caring for her ill father, and she also said that most of her activities of daily living are normal, which is on CAR 975. She also alleged severe difficulties concentrating, and Dr. Brecht and Dr. Brown similarly said she was unable to concentrate. This would be related to her fibromyalgia. Again, the treatment records show the opposite. There's no concentration or other mental difficulties that were noted during testing. That's on CAR 320 and 321. And she also admitted to Dr. Anderson that she had no problems concentrating and read 3 to 4 hours a day. That's on 318 to 319 and 321. She alleged her muscles got really weak. She was exhausted all the time, but exams showed no muscle weakness. They consistently showed her alert and oriented. Dr. Brett consistently observed no apparent drowsiness during exams. And she also alleged debilitating pain half the day in a recliner, but providers consistently observed that she appeared comfortable. She was in no distress, overall good health. And Dr. Anderson noted when she complained to Dr. Anderson that she was currently experiencing 6 out of 10 pain, which is higher than she said her baseline pain was. And I'll just read from the ALJ's decision here. Inconsistent with the claimant's subjective reports of pain to Dr. Anderson, who is a physician, noted that claimant exhibited no pain behavior or deficits in mental functioning during the 50-minute examination. So this was a decision where the ALJ did look at the evidence. He carefully considered it. He considered her work history. He considered the statements of the lay witnesses. He considered her testimony at length. And in a thoughtful decision, he agreed that she could not perform the work that she previously performed. But that is not sufficient to establish disability in this case.
Any further questions? No. Thank you, Counsel.
Thank you.
The commissioner, in far less than 10 minutes, made many arguments about specific contradictions between the medical evidence, what Ms. Collard said on the one hand, and what the medical evidence said on the other hand. The judge did not tie any of that together in her decision. This court is compelled to look at the findings that are set forth by the ALJ in her decision and not to rely on the post hoc rationalizations presented by the commissioner. In particular, the issue with work. The commissioner argued that the judge considered all of the evidence surrounding the reasons why Ms. Collard left work, but her decision states that Ms. Collard stopped working for reasons other than her alleged pain. Specifically, the record does not indicate that she had to quit or was fired because she was unable to do the job tasks. That's simply inconsistent with the record. The record does contain Ms. Collard's testimony that she stopped working because she was having many, many absences and having difficulty performing her work due to pain. If there are no questions.
I don't think.
Your argument is that the inconsistencies relied upon by the ALJ don't match her disability. Is that right?
That's correct. My argument is that especially looking at her original function report that she completed in December 2016, she said, sometimes I cannot drive. Sometimes I cannot do household chores. Sometimes someone else needs to do the cooking. Her symptoms wax and wane. All of the information cited by the commissioner shows that, yes, at times Ms. Collard is capable of performing activities, but she's not able to sustain those activities. She has flares of pain that would require absences, just like she did when she was working, and as she testified to, and as supported by the lay witnesses.
Thank you for your argument, both of you. We'll take that case under advisement and go